All right, good morning, everyone. Happy Friday. We'll give everyone just a few minutes to come into the webinar, and then we'll get started. Just seeing folks still coming on kind of little by little, so hang in there with us and we'll get going. Okay, I'm sure a few folks will still be coming in, but for just to honor time here this morning, we'll go ahead and get started. Welcome everyone to our webinar, CEQA, What's Next? We appreciate you taking time to be here with us. This is part of the Governor's Office of Land Use and Climate Innovation, or LCI, our CEQA webinar series. For those of you who haven't heard, we were renamed last summer from the Office of Planning and Research, or OPR. So same entity doing the same work. Our CEQA work continues, and we'll tell you about what's next for the policy team who is working on implementation of portions of this summer's CEQA trailer bills, AB 130 and SB 131. My name is Patricia Kennedy. I'm the manager of the State Clearinghouse's policy unit. So that includes our planning, CEQA, and policy innovation teams. I'll be your facilitator and moderator throughout the webinar today. We are also joined by Natalie Kuffel, the Deputy Director of the State Clearinghouse at LCI. And so she manages all the teams under the policy unit and then also our data and operations unit, which many of you are likely familiar with as the State Clearinghouse. Natalie will be our main subject matter expert today. Behind the scenes, we have an amazing team of policy experts making all of this happen. So if you're having any IT issues or have any other questions, please put those in the Q&A and we will assist you today. So the webinar today will be broken into 3 parts with a Q&A section after each section. We will first discuss the judicial streamlining expansion for infill housing projects and generally touch on the judicial streamlining program. We'll then move on to infill exemptions and streamlining, and finally we'll close out to discussing the new VMT mitigation bank. Okay, so to ensure our webinar flows smoothly today, I want to take a couple of minutes to go over a few guidelines. Most of our Q&A will be focused on addressing questions that were submitted in advance when you registered. We received many wonderful questions, so thank you for that. But due to our limited time together, we selected questions from your submissions based on the topics that we believe will benefit most of our attendees. You may use the Q&A feature to ask questions throughout the webinar. We actually really encourage it. And additionally, if you use the upvote feature at the bottom of your screen to elevate a question that you would like to see answered, these are the ones that if we have time, we will address at the live Q&A at the end of the session. So we're going to do our best to answer live questions. We might not get to many or any of them, but they will help inform the guidance we produce in the future. One thing to remind everybody, LCI cannot provide legal advice. Not today, not an email. So if your question is something like, hey, I'm halfway through an EIR and I'm wondering if I should switch to using a new exemption instead, that technically would be legal advice, and we recommend that you bring that question to your attorney. Finally, we want to let you know that this session is being recorded. The recording, the slides, and all of the resources and links will be shared with attendees following the webinar. Okay, so let's get started. Who is LCI? Well, I'm sure many of you are familiar, LCI or OPR formally. I'd like to cover some of the basics of who we are and what we do. LCI is the Governor's Office of Land Use and Climate Innovation, formerly the Office of Planning and Research, or OPR. Since 1970, the office has played a central role in implementing CEQA. So we prepare technical advisories to help CEQA practitioners and the public. We help draft initial versions of CEQA guidelines before sending them to Natural Resources Agency. If you are here, you likely know this, but if you're newer to CEQA, we wanted to provide some links in the chat to previous webinars we've done, CEQA 101, CEQA 102. You can navigate those at a later time, and those really provide a good foundation to what CEQA is. So CEQA, or the California Environmental Quality Act, is a state law that requires public agencies to evaluate the potential significant environmental impacts of their projects and plans. The goals of CEQA are to inform the public and decision makers about these impacts, require agencies to avoid or mitigate them when feasible, and ensure that projects are altered through alternatives or mitigation measures to reduce environmental damage. Broadly, CEQA's role is to support informed decision making. And so in this summer's CEQA trailer bills, LCI was given really specific roles. The purpose of this webinar is to walk you through those provisions, tell you more about how we plan to implement them, or the inside scoop, as you'll see throughout our presentation today, and share how to stay involved throughout the process. The State Clearinghouse, as I mentioned a couple times today, has been part of this office since 1973. And it now houses all of the office's traditional functions. And so that includes CEQA implementation, local and regional land use planning, and the environmental goals and policy report. The mission of the State Clearinghouse is to help facilitate informed decision-making by public agencies and the public. We do this by providing events like today's webinar. We provide written guidance, technological tools and resources like CEQA Submit and CEQA Site Check. So all of these are maintained by our Data and Operations Unit. We're also tasked with assisting the governor with implementing the judicial streamlining program, including preparing the program guidelines and reviewing applications. That's the first topic we're going to cover today. So with that, Natalie, I'm going to hand it over to you to tell us about our first topic, the changes to CEQA judicial streamlining found in AB 130.
Thank you so much, Patricia. As Patricia mentioned, my name is Natalie Kuffel, and I'm the Deputy Director of the State Clearinghouse here at LCI. I'm going to jump right in. I know people are eager to get started. So first, what is judicial streamlining? Judicial streamlining is a special certification that's granted by the governor, which reduces CEQA litigation by using special rules of court for both the trial court and the Court of Appeals. Full environmental review is done. So for every project type, a full environmental impact report is prepared. Where the streamlining takes place is after environmental review is done, if there's any litigation under CEQA. That's when those special rules of court kick in, and essentially the project is given a judicial fast pass. So it goes to the front of the line and it goes more quickly than all other cases. This resolves the litigation as quickly as possible, or in approximately 270 days, as required by the statute. There is a long list of bills on our website about when judicial streamlining was created back in 2011 in AB 900. I know some folks still refer to it as AB 900. If you're curious about the full legislative history, we do have that on our website. What we're covering here is the more recent legislative history, including SB 7, which was passed in 2021. That extended the Environmental Leadership Development Project statutory provisions and also added a new category of housing development projects. And that's what we're going to be talking about today. In the summer of 2023, SB 149 was passed, and that expanded the eligible list of projects to include 4 infrastructure project categories. And finally, AB 130 this summer made it easier for housing projects to qualify. Next slide, please. Okay, back one slide. There you go. So how did it do this? The first provision related to judicial streamlining that was changed by AB 130, can be found in Public Resources Code section 21180, subdivision B4. And this change was pretty straightforward. As you can see on the screen, the housing projects no longer have to be small. Originally in SB 7, there was a requirement that these projects be between 15 million and $100 million. We do have a large infill project category that covers projects over 100 million. This summer that was changed and the restriction on $100 million was removed. So now any project that invests at least $15 million is eligible to apply. So what this means is that projects that are over $100 million can use the easier to meet small infill standards rather than the more stringent large infill standards. Next slide. So the small infill standards are easier to meet because there are fewer requirements. For the large infill projects, they have to be LEED Gold certified and meet certain transportation efficiency standards. You don't find that in this other infill housing category. The few requirements that there are have been on the screen, so you can take a look at those. We wanted to highlight the other change that was made by AB 130, and that relates to the requirement about GHG emissions. So instead of demonstrating that the project won't result in any net additional GHG emissions, which is the current criteria, now the projects can show that they demonstrate consistency with the most recent scoping plan that was adopted by the State Air Resources Board, or CARB. So previously, by showing no net additional GHG emissions, a lengthy quantitative analysis was done that involved extensive emissions modeling and usually required hiring a consultant. Now applicants can still choose to use that method if they would like, but now they can also demonstrate consistency with the scoping plan as an alternative. We expect that this will make applications less expensive and also provide more certainty to applicants that they're going to qualify for judicial streamlining before ever submitting an application. Next slide, please. So as I mentioned earlier, this is just one project type out of 8. There are 4 projects under our environmental leadership development category, and then 4 projects in the infrastructure category. We're not going to go into all of the requirements of these projects, but we wanted to point out that there is a really helpful feature on our website where you can click on each project type, and the requirements for each are easy to navigate and located in one place. And we'll be putting that link in the chat so you can use that at a later date. All right, next slide. So what's the inside scoop on how we plan to implement this provision? So staff in LCI's CEQA Judicial Streamlining Program are going to be updating the guidelines to clarify the ways new housing projects can demonstrate consistency with CARB's scoping plan. This guidance will likely include a list of types of attributes housing projects should have in order to be consistent with the scoping plan, including the list contained in Appendix D of the scoping plan. So if you want an early sneak peek, check out Appendix D of the scoping plan. One thing to note is that CARB plans to release a new version of the scoping plan no later than 2027 and to update it every 5 years thereafter, at which point LCI will likely have to update its guidance to make sure that projects are still consistent with the most recent scoping plan. All right. Now let's move on to Q&A.
Okay, great. Thank you, Natalie, for all of that information. So let's dig into some of the questions that were submitted ahead of time, like I said, with the webinar registration. So Natalie, what if I don't know if my project will be a good fit for judicial streamlining? Are you and your team open to meeting with potential applicants to talk through this?
Absolutely. So one thing we emphasize about this program is it's very different from grant programs. Applications are handled on a rolling basis, so folks can reach out at any time. There's no deadline to apply other than the current statutory sunset deadline, which is still 7 years away. So we have plenty of time, and we are always very happy to sit down with folks and talk through the requirements, look at early drafts of applications and provide feedback. So don't hesitate to reach out, and we'll have contact information at the end of the presentation that you can use to do that.
Great, thank you. When should a project or an applicant consider submitting their application? Is it before or after their EIR?
Yes, this is a question we get a lot. Recently, we also got a question like, can I wait until I see if someone sues my project under CEQA? And the answer is no. Don't wait till then. It will be too late. So you really do have to think about this earlier in the process. We recommend applying before the draft EIR is released. And what we've noticed is that applicants tend to apply around the time that they're getting ready to release the draft EIR. And this is because analysis that's done in the EIR can really be helpful in the judicial streamlining application as well. So if it's already been prepared for the EIR, it's easy to translate it over to the application for judicial streamlining. It's also important to note that one of the main ways that litigation is streamlined under judicial streamlining is through concurrent preparation of the record. And statutorily, that kicks off when the draft EIR is released. That's when the lead agency has to start posting publicly the documents that will be part of the administrative record. So it's best to know that you are going to apply for judicial streamlining around the time that you're releasing the draft EIR. That being said, we have worked with applicants who have already released the draft EIR. You just have to get certified prior to the final EIR stage.
Okay, great, thank you. I think that's really helpful for a lot of folks that are on. Okay, so question with some of the new laws, won't most housing projects be exempt?
Great segue to our next section where we're going to talk about the exemptions and streamlining options that were created this summer for housing projects. So yeah, the hope is that there will be more housing projects that are exempt from CEQA after this year's bills. But important to note that no matter what level of environmental review is done on a housing project, there is some element of streamlining available. So judicial streamlining is available if that housing project happens to do a full EIR. There can still be streamlining in the form of litigation relief that makes sure that that project is constructed as quickly as possible to help meet our housing needs.
Great, thank you. So in honor of time, we'll keep moving, and I think everybody's really excited now to hear about infill exemptions and streamlining. So with that, I'll go ahead and hand it back to you for our next segment.
All right, thanks, Patricia. So, making it easier to build in infill areas, especially housing projects, was the big focus of this legislative session and the budget trailer bills. This is often referred to as the housing as a climate strategy approach. It helps address California's housing shortage and affordability crisis by making it easier and faster to build new housing, while also increasing access to daily destinations via active and public transit. This allows residents to reduce their vehicle miles traveled and associated greenhouse gas emissions and gets us closer to that best possible future that we're all trying to achieve, which we're hoping does not look like the image on the screen. Next slide. So one of the ways that was done in this summer's trailer bills is by creating a new exemption for infill housing. It began as Assemblymember Wick's AB 609, so folks may still think of it that way, before being incorporated into AB 130. Now you can find it in Public Resources Code section 21080.66. This exemption applies to projects that meet specific criteria, such as being located on a previous developed land in urbanized areas or incorporated cities, being consistent with local zoning and general plan standards, meeting minimum density requirements, and not being located on contaminated sites. It also can't involve the demolition of historic structures, existing housing, or disruption to sensitive lands like wetlands and farmland. It also includes labor standards and tribal consultation requirements. Both of these provisions have been common in the ministerial project bills, like SB 35 after it was amended by AB 168 back in 2020, but it's not as common in a CEQA statutory exemption. So that's something we wanted to highlight here. Next slide. So LCI doesn't have an explicit role to play in implementing this particular statutory exemption, but we did want to note that we'll be updating two of our popular resources, so it includes this exemption. The first is our written TA on CEQA review of housing projects, which will be updated to include this new exemption as well. And then we'll also include it in our CEQA site check mapping tool. Site check is going to play an important role in implementing these new trailer bills, and we wanted to highlight that we'll be refreshing the data and making the tool more user-friendly as part of our implementation efforts. And you'll hear more about that later in the presentation. Next slide. So moving on to something that does have a directive to LCI. LCI was directed to update the infill performance standards, which are included in Appendix M of the CEQA guidelines. They were added pursuant to SB 226 in 2011 and are contained, can be found in Public Resources Code, Section 21094.5. SB 226 can lead to a full CEQA exemption or streamlining. It can be a full exemption if the lead agency prepares a written checklist that demonstrates that all potential effects of the project are either addressed in a prior EIR for a planning level decision. And that's the case even if those effects were not reduced to a less than significant level in the prior EIR, it's enough that they were addressed. Or they can show that it was addressed by uniformly applicable development policies and standards that were adopted by the lead agency. And so that's the full CEQA exemption. If a project would still result in significant effects and an MND or a sustainable communities environmental assessment can't be prepared, the EIR for an SB 226 project does not need to consider alternative location, densities, or building intensities, or the growth-inducing impacts of the project. So what has been on the screen this whole time, and I hope you've had a chance to look at because I will not read it to you, is the directive of what needs to be included in these infill performance standards. That hasn't changed by this new bill. So these are the goals that we'll be continuing to consider as we update the infill performance standards. What has changed is on the next screen. So please click to the next slide, Anna-Sally. All right, and that is subdivision C. So you can see the previous language at the top, which just required LCI to update the infill performance standards as needed. But what is included now is a requirement to update these infill performance standards on or before January 1st, 2027, and at least once every 2 years thereafter. The legislature has also given us some explicit things to think about as we update the infill performance standards, mainly in attempts to provide clarity and also reduce any potential litigation risk. Next slide. So this is what is currently said about housing projects in the infill performance standards. There is a locational criteria. A project has to be located within a half mile of a major transit stop or a high quality transit corridor that's either existing or planned and funded in the RTIP. Or it can be in a low vehicle travel area. This is just an area that has below regional average VMT on a household basis. For folks who've seen those maps in SiteCheck or some of the MPOs prepare, this is the yellow zone. So it's not 15% below regional average, it's just below regional average VMT. And then there is another exception if it's a 100% affordable housing project with 300 or fewer units. It doesn't have to be located near transit or in a low VMT area. An affordable housing project qualifies regardless of location, as long as it's 300 or fewer units. Additionally, if the site that the housing project is being developed on is on the Cortese list, meaning that there was some previous site contamination, they must demonstrate that they have completed soil and water remediation as part of the use of this exemption. And if the project is located near a high volume roadway or other significant source of air pollution, it must comply with the air district or local requirements that promote public health. Next slide. I wanted to note that housing is not the only project type that can qualify for SB 226 streamlining. There is also streamlining for commercial and retail projects, office building projects, transit, schools, small walkable community projects, which are defined in the statute and are for areas outside of an MPO, so the more rural parts of our state, and also mixed use projects that are any combination of those list of projects. And Appendix M currently includes performance standards for each project type. So we will be revising Appendix M's infill performance standards, and that may include more than just the housing category. So that's part of our inside scoop. Additionally, we expect that the work that we're going to do on our judicial streamlining guidelines as we think about what are the attributes that a housing project needs to have in order to help us reach our long-term climate goals as outlined in the scoping plan will influence this work as well. We will also look at the remediation and stationary source exposure language that is in the new CEQA exemption as the most current direction from the legislature and how to address those issues. And we expect that our new mapping initiative will also support this effort on infill performance standards as well, which takes us to our next section on infill mapping. So another clear directive that we got in this summer's bills is contained in Public Resources Code 21083.03, and it requires LCI to map eligible urban infill sites within every urbanized area or urban cluster in the state, and we have to do that by July 1st, 2027. The definitions for urbanized area and urban cluster are on the screen. So just noting that they refer to those areas as defined in 2012. So that's what we'll be using for this mapping exercise. The term eligible infill site is a new term. It was previously attached to some amendments to the Class 32 categorical exemption, but that language did not continue on into the final trailer bill. All right, next slide. So in terms of how we are supposed to map eligible urban infill sites, there's language provided in the statute. The site has to have a land use designation that's consistent with infill development as set forth in the local jurisdiction's most recent general plan or adopted and certified housing element. And the development on the site has to promote compact development in order to accomplish specified goals relating to improved environmental and community impact. This is a different approach than most infill definitions take. Next slide, please. We'll see what's a little more common. So this is language from that new housing exemption in section 21080.66 that we just talked about. This is how that exemption defines infill. Provisions A and B are pretty common. First, you would look at whether the site has previously been developed with an urban use. Sometimes it's also referred to as a qualified urban use. And if it's not, then you look at the development that surrounds the parcel. And there's variations here in terms of how much the parcel has to be surrounded by urban uses or qualified urban uses. But generally, they follow the same format. Interesting to note that this new exemption adds provisions C and D here, which are additional ways to show that the parcel is surrounded by urban uses. even if it is not as clear that it touches all three sides of the perimeter. Okay, next slide, please. So in creating this map, it is exempt from the APA, so there won't be a formal rulemaking process, but the public process is outlined in the statute that we have to comply with, both for the original adoption of the map and any subsequent amendments to the map. So as part of the map development process, LCI is required to transmit a draft map to the Board of Supervisors of any county and the council of any city or town that has been included. So any that have one of those urbanized areas or urban clusters. And we have to do that at least 120 days before adoption of the map. Cities and counties then submit comments to us on the draft map within 45 days. And then after making revisions, LCI posts the map on its public website for at least 45 days and conducts at least one public meeting and receives comments. After we've considered all of the comments that we've received, we will publish the map on our website and transmit a copy back to those local governments that we engaged with earlier in the process. So inside scoop on this one, we expect that the new map will become part of our site check mapping tool. And if you look at all of these provisions together, what you see is a general theme asking us to prepare guidance on where we should build, which is that mapping portion, and then also how we should build, which are the performance standards. And together, this creates objectivity and certainty and reduces litigation risk because it is clear to say we're located on this part of the map and we meet these objective performance standards. And so that is part of the goal of this legislation. And we look forward to implementing it. All right, next slide. So we also wanted to cover the near miss provision. This is another one where LCI wasn't given an explicit role in implementing this provision, which was added in Public Resources Code section 21080.1. But we received a lot of questions about this provision and wanted to provide some tips that may help lead agencies with implementation. But first, what is the near miss provision for those that don't know? Under SB 131, if a housing project would qualify for a CEQA exemption, but for a single condition of that exemption, then CEQA review of that housing project is limited to the environmental effects caused by that single condition. So the CEQA analysis for these near miss provisions is only required to examine the environmental effects that are caused solely by the presence of that single condition that precluded use of the exemption. Also, environmental impact reports for these near miss housing projects are not required to include any discussion of alternatives to the project or growth inducing impacts. You saw that similarly in SB 226. So that's a pretty common streamlining provision that's been included here as well. Also wanted to note this language that's on the screen is that a project must be similar in kind to the type of project contemplated by the exemption. Accordingly, if the CEQA exemption is for a transit-oriented development and the single condition that isn't met is that the project isn't near transit, you might want to consider whether it is similar in kind to those that were contemplated by the exemption originally. Inside scoop on this one, LCI may elect to provide guidance on this topic given the number of questions we've received. But in the meantime, we wanted to note that Site Check can be a helpful tool for local governments and developers trying to navigate this new provision because it contains all of the exemptions and streamlining provisions that could apply to a housing project, obviously minus the new one that was passed this summer, which we'll be adding in. And it breaks down each exemption into a list of conditions. SiteCheck then uses spatial data to provide an early indication of whether a condition might be met, but want to emphasize that further validation is required by the lead agency. And as mentioned earlier, we are going to be updating SiteCheck's data layers as part of our implementation work. So stay tuned for that update. All right. And now I'm going to do what they always tell you never to do in a live webinar, and share my screen and show you how to navigate to SiteCheck in order to get one of these reports. All right. So if you went to sitecheck.lci.ca.gov, this is what you would see. You can create an account and be a logged in user, or you can just continue as a guest. Um, the Explore feature includes all of our mapping layers, and this is where our new data layers that we create to implement these provisions will be kept in the future. But what I want to show you is the Analyze feature. So if you type in an address or a PN or zoom in on the map, you can get to parcel level details. You can select one or more parcels to align with the project you're considering and hit Create Report. Once the report is created, if you scroll down, you can see that all of the relevant statutory exemptions, categorical exemptions, and streamlining provisions are included all in one place. And if you click, you can expand it out and find that each condition is noted here along with the definition. And then based on the spatial criteria or the spatial data layers that we have, we've given some indication of whether we think that spatial criteria has been met. And then as you scroll down, you can find the non-spatial criteria like the type of housing or SES consistency that would also have to be considered as part of this analysis for the near miss provision.
Great. Thank you, Natalie, for being brave and taking us through that demo. Stay ready because I think we might have another one coming up based on some of our questions, but first, some potentially easier questions for you. Can you tell everyone attending how they should be citing the new statutory exemptions?
Yeah, so I would cite it based on the code section, which, as we mentioned, is Public Resources Code section 21080.66.
Great, thank you. Do we know if an NOE has been filed yet in the state clearinghouse for any of these new exemptions?
Yeah, that is a great question and one that we get often. So I thought it would be good to show folks how they can see for themselves what's been submitted to the state clearinghouse. So don't send an email and wait for our response. Just head to the website and you can find it for yourself. And the website to go to is sequanet.lci.ca.gov. And it will take you to a page that looks something like this. And then you can click on the search function or advanced search if you need something a little more complicated. But here we're going to type in that code section, hit the search, and then you can see here all of the projects that have already been submitted that included a notice of exemption citing that specific provision. So you can click through and see how they're citing it, what they're putting in their notice of exemption. And one thing that I wanted to highlight is that notices of exemption under CEQA are generally optional. If a notice of exemption is filed, it reduces the statute of limitations. So lead agencies typically will elect to file a notice of exemption, but unless the exemption itself requires it, it is optional. So the language that's in AB 130 did not include a requirement to submit a notice of exemption to the state clearinghouse. But in the bill that amends that language, SB 158, which I believe is still on the governor's desk, there is a provision that would require submitting a notice of exemption to LCI State Clearinghouse every time this exemption is used, just the new housing exemption. So going forward, folks should be able to have a really clear record of every time that exemption is used in the state.
Okay, great. So currently not required. In the near future, we're anticipating it might be. Thank you for that clarification. Does the exemption apply if a project deviates from development standards?
So to qualify for this specific exemption, the project must be consistent with the applicable general plan and zoning ordinance, unless it is a builder's remedy project. And then there's other portions of the state housing law that govern whether such ordinances may apply. Um, and in terms of the actual language that requires consistency with planning and zoning law, it is a little bit unique. So we wanted to put it up on the screen so folks could see it. So this is what it says in terms of consistency. Wanted to highlight the bolded language that a housing development project shall be deemed consistent with the general plan or zoning ordinance and any applicable local coastal program if there is substantial evidence that would allow a reasonable person to conclude that the housing development project is consistent. That language is kind of unique, so we wanted to draw everyone's attention to it so they knew what standard would be met. All right, thanks, Adesale.
Okay, great. Thank you for that clarification, Natalie. I'm gonna bounce around a little bit. We did receive a couple of questions on how these might impact tribes and tribal consultation, and I see some questions in the chat. So can you just talk a little bit about how this might impact tribes, tribal consultation per AB 52, and whether or not some of these new exemptions would in fact allow jurisdictions to bypass tribal consultation under these laws?
Yeah, thanks, Patricia. So, tribal consultation under AB 52 is required when a negative declaration, mitigated negative declaration, or an EIR is prepared. It's not required for exempt projects unless it's explicitly included in the exemption, which we did see with this new housing exemption in AB 130. There are other new exemptions in SB 131 that we didn't cover here, and they don't include a requirement to conduct tribal consultation. But despite that, a lead agency could still elect to conduct tribal consultation, and we are seeing this in the context of the new land restoration statutory exemption. The Department of Fish and Wildlife is conducting tribal consultation as part of this process, even though it's not explicitly required in statute.
Okay, great. Thank you. And somewhat related to this, I know the planning unit right now is taking on the general plan guidelines update, and in association with that is also taking on updating our tribal consultation guidelines under AB 52 and SB 18. Can you speak to that a little bit?
Yeah, so we are kicking off this process. I think our big rollout is happening as we speak. So letters will be going out to tribal leaders. We really would love to have tribes and local governments engaged in this process as we think about how we can have more meaningful tribal consultation, both in the context of CEQA, which is AB 52, but also for general plan projects, which is required under SB 18. And I know this is your particular area of expertise, Patricia, so anything you'd like to add about this project?
Yeah, I think we'll have more discussions down the road, but I think really just overarching the question that came in, would love to chat with whoever submitted that and really, really encourage you to engage with us in the tribal consultation guideline process. We have some great consultants we're working with, and we are very committed to meaningfully engaging with tribes and re-envisioning what these guidelines look like. Okay, I think we have some more. Can you explain if the new AB 130 CEQA exemption can be applied to mixed use projects?
So it does apply to mixed use projects as long as 2/3 of the project's total square footage is dedicated to residential use. So if you imagine like a ground floor retail with some residential on top, that would qualify as long as 2/3 of the project is residential.
Okay, great. Um, What's the difference between the new AB 130 exemptions and Class 32 infill exemptions?
Yeah, this question's been coming up a lot. I think there was a lot of focus this summer on the Class 32 exemption, so really brought it to the forefront of folks' minds. One thing to note is the Class 32 exemption is a categorical exemption, so that is established via the CEQA guidelines through the regulatory process. It's something that LCI and the Natural Resources Agency decide together, and it's classes of projects. So there's categories. That's what makes it a categorical exemption, as opposed to statutory exemptions, which are created by the legislature. And they're considered a little more absolute. So categorical exemptions, because they cover a broad class of projects, contain exceptions, like the unusual circumstances exception, which can make them a little more vulnerable to legal challenges and delays. So statutory exemptions are generally viewed as a little more bulletproof. Um, and for AB 130, one thing I don't think I emphasized earlier, but is a really important addition with that particular exemption, is that it can apply to projects on sites up to 20 acres. In comparison, Class 32 is limited to projects that are 5 acres or less. So that's a pretty big difference. So if you have a larger project and are looking for an exemption, the new AB 130 exemption might cover your particular project.
Okay, thank you for that clarification. I think we could keep talking about this probably all day if we wanted to. But for the sake of time and in order to make space for discussing VMT mitigation banks, I think we're gonna move on. So with that, I will hand it back over to you, Natalie, to discuss VMT mitigation bank.
All right, thanks, Patricia. So this is the biggest directive that we've been given in this summer's CEQA trailer bills. We saved the biggest for last. Pursuant to Public Resources Code 21180.44 in AB 130, LCI is tasked with working with HCD and other relevant state agency partners to create a statewide mitigation bank for transportation impacts. It's important to note that this statewide mitigation bank will be a CEQA mitigation program, so accordingly, it needs to be designed and administered in a manner that satisfies all of the statutory requirements for CEQA mitigation, um, and we are working on that as we speak. The Governor's Office of Executive Order EON 224 had already tasked LCI with developing a framework for statewide mitigation banks, so this is just an extension of that work. It's an optional mitigation bank that will provide a way for lead agencies and applicants to easily use offsite mitigation to mitigate any significant transportation impacts. In terms of LCI's role, you can see some of that statutory language on the screen. By July 1st, 2026, we are tasked with developing a methodology for determining the amounts that are required to be contributed to the bank, aka the Transit-Oriented Development Implementation Fund. This is the fund that will be used to construct the affordable housing and related infrastructure that will serve as VMT mitigation in this program, and HCD will administer and manage that fund. We also need to create a definition of location efficient areas. Projects in location efficient areas will be prioritized as VMT mitigation. Next slide. One of the main tasks will be determining how much a project should contribute to the bank to purchase mitigation credits. We'll be working with technical experts with VMT mitigation bank experience to determine the appropriate amount. And finally, the guidance will include a methodology for estimating the anticipated reduction in vehicle miles traveled associated with those affordable housing or related infrastructure projects that are funded by the bank. Next slide. So this additional section on the screen tasks LCI with aiding in the vetting and confirmation of those estimated reductions. So we'll be providing technical assistance and expertise to HCD to the specific methodology and approach and actual confirmation of VMT reduction associated with these location efficient projects that are eligible for funding through the bank. LCI and HCD will ensure that projects funded achieve measurable, additional, and permanent VMT reductions in accordance with CEQA mitigation requirements. And we will implement monitoring and reporting mechanisms that are required to maintain the credibility and meet those CEQA requirements regarding monitoring and reporting. All right, next slide. So inside scoop on the VMT mitigation bank, as I mentioned, we do have to define location efficient areas. This will likely be influenced by our other mapping work that we're going to be doing as discussed earlier, which you noted in the compact development section requires a look at location efficiency. And this final map, as we mentioned, will be included in SiteCheck, so it'll be available for all to see.
Okay, great. Thank you. Lots of work ahead for sure. We're going to move on to our final Q&A session. We don't have a lot of time, but we'll spend a few minutes on some Q&A that we received live, and then we'll wrap it up and discuss a little bit about what's next. So Natalie, regarding the near miss provision, to qualify for an exemption, this is going to be kind of like a longer question, so bear with me here for a second. To qualify for an exemption, can you clarify what would qualify as like a single condition? So the code says a condition means a physical or regulatory feature of the project or a setting or an effect or its setting or an effect upon the environment caused by the project. So can one condition qualify as near miss under two, or can you kind of just like dive into that a little bit? What does it mean? What does near miss mean? What does one condition mean? How are people evaluating this? Can you kind of help us unpack that a little bit?
We're looking at the same statutory language that everyone else is. As you mentioned, Patricia, there is a definition for condition in the Public Resources Code that folks can look at. We pulled up the SiteCheck report because I think, in my mind, that's what I think of is all of the statutory requirements that must be met in order for a statutory exemption or a categorical exemption to be used. Generally there is a list of requirements that a lead agency has to go through. So that can be a helpful starting point as we think about how to implement this new provision. In terms of whether two conditions can not be met and still use the near miss provision, there is a lot of clarity on that point. It is only one single condition that kicks you out of the exemption that would allow you to use this near miss provision. If there's two conditions that aren't met, unfortunately, you'll be doing the same process that currently exists in CEQA, prior to the addition of this near miss language.
Okay, thank you. That's helpful. Araceli, can we go ahead and share the presentation, and we'll go over some next steps, what's next, and wrap it up. Okay, so first I just want to thank you, Natalie. You shared a lot of information today. There's more to come, and also want to thank all of our amazing staff working behind the scenes, Araceli, Heather, Zach, Julian, and Chris, really making this happen today. Thank you to everyone who is attending or watching the recording later, I suppose. Please keep submitting questions about these new bills. You can submit them we might not be able to respond to each question that we receive in our email, but we do use these to help inform the future guidance that we're going to be preparing, future webinars, technical assistance, right? These questions really do help inform what we do next. So we really recommend that you keep asking those questions. Let's see, what's next? Coming up here, fall and winter of 2025, we will be hiring. Keep a lookout for a CEQA attorney position and 2 staff positions to help support this work that LCI has been tasked with in the 2 new bills. Under that, we will be updating the judicial streamlining guidelines, as Natalie mentioned. We will begin public outreach on guidance and guidelines. And we do plan on hosting a webinar on the lead agency's role in the judicial streamlining program. So a little bit more focused, but hopefully can cover that topic for those interested. In next spring of 2026, we will be finalizing our VMT mitigation bank guidance. And we will be beginning our outreach on infill performance standards and the update to those. And then following that, in summer or fall, we will finalize our CEQA guidelines for submission to the Natural Resources Agency. And we also hope to start engaging with local governments on mapping provisions ahead of the 7/1/27 deadline. So I think I mentioned it already, but once again, in addition to all of this great work that our CEQA policy team is doing, also want to plug the planning team. They are undertaking the general plan guidelines update, and as well as I had mentioned, the tribal consultation guidelines update, which is a pretty big thing for us, and we think for a lot of the folks that we work with. If these topics interest you, I really do encourage you to sign up for the planning guidelines listserv. Let us know what you're thinking, submit your questions. I think I'll go to the next slide. Okay, and with that, I just want to thank you all one last time. I encourage you to join our CEQA mailing list, stay involved. Look forward to the next time. I'm going to hop over the Capitol and go to Native American Day. If you're here local, I recommend you do the same. Maybe we'll see you over there. Otherwise, have a great weekend, and thanks for joining us today.